prior to 2002, I would assume, and again, I'm from Williamsport, Pennsylvania, and I would assume, well, it is a fact, we're about 4 to 4.5 hours drive time to Philadelphia. So is there any evidence or facts that would support that prior to the fix, that just the threat of taking the case to Philadelphia would be cause for a out-of-court settlement?
Yeah, I mean, certainly the possibility and the threat of venue shopping might lead to higher lump sum settlements. I mean, greater liability means greater risk, right? And risk has upward pressure on insurance premiums and, by extension, the cost and availability of insurance, right? So if that's a factor for access to health care, the threat of venue shopping certainly drives up frequency and size of lump sum settlements. And besides the fact, I mean, cases that might not have otherwise been brought, say in Lycoming County, would be brought in Philadelphia. So the volume of litigation would increase too.
Okay, thank you. And this was brought up by a constituent of mine that happens to be an attorney, and it had to deal with the concern that limiting venue exclusively for the medical malpractice cases, that we are somehow creating, I believe he said, a special class.
Yeah, that's a frequent critique of the medical malpractice venue rule, that a certain class of defendants shouldn't have special rules. Like I said in my testimony, it's our contention that the venue rule for medical malpractice should be extended to all civil litigation.
Okay.
That would be inherently fair, I think.
Now, you practice in Lancaster. Mm-hmm. You're relatively close to Philadelphia. Within, what, hour?
Hour and a half. Mm-hmm.
Hour and a half, okay. So now we got to imagine that, and pick another county. Let's call it Erie, let's call it Allegheny, which is significant distance from you. So, and let's assume that they were the counties that these awards were lucrative. So if venue shopping were allowed, and there was a suit brought against you, and they wanted to move it to, again, pick a county, let's say Erie, I mean, you're going to be faced with maybe many nights away from your practice, away from your hospital, simply because of the distance. Mm-hmm. This court case could go on for a week or more. How would that affect your defense and your defense counsel? Would you be willing to settle out of court so that you're not away from your practice? Would you be willing to offer money out of your own pocket to settle this? I'm just trying to figure out how you would deal with that something. And at the same time, you being able to have empathy for the folks that are so far away from Philadelphia. You know, the doctors in Erie that may have to go to Philly under the current situation or proposed, rule change. So I'm just, how would that affect?
I suppose, as far as being away from my practice, that would clearly be a hardship for my patients and for my partners. It wouldn't necessarily be a deal breaker for me not going, because it depends a bit on the situation. Another way that it would affect my practice, and perhaps the practice of others, and I didn't mention this before, is practicing defensive medicine, that if I had been sued, would I practice any differently going forward? I like to say, and most of my partners will say, we practice evidence-based medicine. We try to adhere to the guidelines that are put forth by our colleges. But do you overorder? Do you overorder diagnostics? Do you overconsult? Do you drive up the cost of healthcare, drive up the cost of patients in a time when value-based medicine is paramount? So that's perhaps another answer to your question, but it does affect having to be away. Again, puts a strain on that duty to my patient, and more importantly, a duty to my population that I'm caring for. I hope that answers your question.
But is in your experience talking to other physicians, and Dr. Powers, maybe you want to chime in on this one, does it or will it, I guess is the proper way, will it affect the settlements?
I can tell you, we have a case that a board member of ours very eloquently brings up. Yes, the fear of going to Philadelphia caused them to settle a case that they not only felt they had done nothing wrong on, they were actually the one who diagnosed the problem and corrected it. But when the lawsuit came, they sued everybody in the chart, if you know what that means, and he actually settled because even though he had found the problem and corrected it, he was named and he didn't want to risk going to Philadelphia. So, yeah, I think it would.
And for full disclosure, my wife is a director at Evian Hospital in Lewisburg, and that's exactly what I was trying to get out
Right.
on the record. This does, or did go on, your defensive medicine drives up costs tremendously. And everyone would prefer to practice evidence-based medicine. But when you're in such a potentially going into a very litigious scenario, wow, is it going to cost a lot of money? In your testimony, you had mentioned West Virginia. Now, West Virginia, have they done anything to correct their system? Are you familiar with that?
The only thing I could say about West Virginia is that our company ceased to operate in West Virginia. We sold those facilities. So what the state has done as far as reforms, I'm not sure, but I can also certainly let you know that.
And the reason your company pulled out of West Virginia was?
Well, I don't speak for my entire company, but I can tell you, sitting at the table in our corporate meetings, the litigation environment in West Virginia was unmanageable.
So basically, cost of doing business was
Correct.
extremely high in West Virginia.
Correct.
And the corporation chose to pull out.
That is correct.
Okay.